Assalamu alaikum, everyone, and welcome to CARE Michigan's 11th session of the History of Resistance and Racism in America. My name is Zainab Fahas, and I am pleased to present and welcome Attorney Mona Youssef, who will be joining us this evening. Assalamu alaikum, Sister Mona, how are you?
Wa alaikum assalam. Alhamdulillah, thank you for inviting me.
Thank you for joining us this evening. So Attorney Mona will be leading this evening's class on the history of segregation. Sister Mona is a referee in the Wayne County Juvenile Court and has been since 2010. As a referee, she presides over child abuse, neglect, and juvenile delinquency proceedings and makes recommendations to judges, which subsequently become orders. Sister Mona obtained her bachelor's and JD from the University of Michigan and has worked in private practice with a heavy pro bono component, and the vast majority of her legal career has been in public service. So we are very pleased to have you on with us. Just a few housekeeping items before I pass things on to you. For the viewers, if you are watching this live or later on, please share this with your friends and followers so they can learn with you. While you're on social media, go ahead and make sure that you are following CARE Michigan on Twitter, Instagram, and Facebook. And if you have any questions as you're watching this live, feel free to drop them in the comment section on Facebook or YouTube, and Attorney Mona will be able to address those at the end. So without further ado, I'm going to pass it along to you.
Okay, assalamu alaikum. And again, it's my honor to be here. And it is my honor to present to you a brief history of school segregation in the United States. I've learned a lot in preparing for this presentation, and inshallah, you'll also learn and benefit. And this, again, is just a brief summary because really we could, this is, multiple courses could be taught covering the same subject matter. I titled my presentation Beyond Brown, Brown, Green, Red. And the reason I chose that title is because I think most people are familiar with, I've learned a lot in preparing for this presentation. Okay. My apologies for the background noise. Most people are familiar with the Brown case, which is Brown versus Board of Education. That was became the law of the United States through the Supreme Court in the mid-1900s. So we're going to talk more about that later on in the presentation. After Brown, there was a case called Green, which really accelerated school desegregation. And then we get to more modern history, 1970s, 80s, 90s, and we see the starting of a break on and a slowdown in school desegregation. So brown, green, red, keep that in the back of your mind. And inshallah, we will go through and talk about a lot of the case history. So bear with me for a minute while I just make sure. Yep, okay. So throughout my presentation, I'm going to talk a lot about case law and statutes. And that's pretty much how U.S. law is developed. With school segregation and desegregation issues, a lot of the framework of the law is built through case law, particularly case law from the U.S. Supreme Court. And for those who are not as familiar, the U.S. Supreme Court is the highest authority in our land in the United States. The U.S. Supreme Court is the final arbiter of what the law is. It determines the application and interpretation of the law. It functions as the guardian and the interpreter of our U.S. Constitution. So it's the highest court that you can get to. With that in mind, oh, and one more bit of information is that the U.S. Supreme Court is made up of 9 justices. And so when I do mention cases that come from the U.S. Supreme Court, I do try to mention at the bottom, like you'll see there, it says was a 7-2 decision. And that is the breakdown of the 9 justices and how they voted. And I just find it informative, and inshallah you can benefit from knowing that as well. So we'll start in the mid-1800s, and just put in the back of your mind, in 1849, there was the Roberts versus City of Boston case. That was a Massachusetts case. It did not go to the US Supreme Court, but the US Supreme Court is later going to reference it. It's a state court case, goes to their highest court in Massachusetts. And in that case, the Massachusetts Supreme Court rules that segregated schools are permissible under their state constitution. Keep in mind, this is Boston, Massachusetts in the north. Most people are familiar with a case called Dred Scott versus Sanford. And this is a case where Dred Scott is enslaved in the South. He's able to escape. He comes to the north. His slave master chases after him. And then there's a series of court battles as to whether or not Dred Scott is free or not. And when the case finally gets to the US Supreme Court in 1857, and trigger warning, if you read the actual case, the language in it will make your blood boil. I mean, it's really, I put in a couple of quotes here for you to get an idea of the flavor of that case. But basically, the US Supreme Court denies citizenship to Blacks. It rules that descendants of slaves, and I put this in quotes, and like I said, trigger warning, it says that they are so far inferior that they have no rights which the white man is bound to respect. They go on to say that Blacks are not included and were not intended to be included under the word citizens in the US Constitution, and that they therefore can claim no right or privileges which the Constitution provides and secures to citizens of the United States. And that was a 7-2 decision. So 7 of the 9 justices were in agreement with that decision. As we move on into the 1860s, and we've got the Civil War going on, in 1863, President Lincoln issues the Emancipation Proclamation, which is supposed to free slaves in the southern states. We have the Civil War going on. It really doesn't have a practical effect as of yet. In 1865, the Civil War ends, and we have the enactment of the 13th Amendment to the Constitution. That amendment is intended to ban slavery. It also bans involuntary servitude. Note that there's an exception, and that exception is except for punishment for a crime which a person is duly convicted of. And so essentially, criminals, or whoever is deemed a criminal, can be subject to involuntary servitude. In 1868, a few years later, we have the 14th Amendment, which guarantees equal protection under the law, and it grants citizenship to Black Americans. In 1875, the US Congress enacts the Civil Rights Act of 1875. And part of the intent of that, and the language of that, is to ban racial discrimination in public accommodations. And what public accommodations includes is hotels, trains, restaurants, public spaces, theaters, etc. A few years later, however, the US Supreme Court strikes down those provisions of the Civil Rights Act of 1875. And that was, there's a series of 5 consolidated cases. They call them the civil rights cases. And there the Supreme Court found that discrimination by private businesses or individuals was really beyond the reach of Congress, and that if there's private discrimination going on, that's okay, that's constitutional. That was an 8-1 decision by the Supreme Court. And so that opens the door for all these Jim Crow laws, mostly in the South. And Jim Crow laws are basically, there's a whole slew of them, a series of laws that mandate segregated accommodations. You have the separate bathrooms, you have separate seating, separate train cars, etc. And all of that was allowed to be the law under these Jim Crow laws, and the Supreme Court opened the door for that. In 1896, we have Plessy versus Ferguson, which is another very well-known case. And in Plessy, the US Supreme Court rules that the separate but equal doctrine is constitutional. So that if a statute implies merely a legal distinction between white and colored races, that does not destroy the legal equality of the two races. So it at least recognizes legal equality of the two races on its face, but it says separate but equal is okay. Moving on, we're getting closer to the Brown decision. In 1940, this is just a lower district court federal case. It happened in Virginia, Alston versus School Board of Norfolk. That's a federal court case which ruled that Black teachers and white teachers have to be paid equal salaries. And there was a lot of backlash for that decision in Virginia. By 1954, we get to Brown versus Board of Education. And in that case, the US Supreme Court overturns Plessy. They find that separate is inherently unequal, and that segregated public schools are not equal and they cannot be made equal. And note that this is a unanimous decision of the US Supreme Court. So all 9 justices voted in favor of Brown, saying that segregated schools are absolutely not permissible, and that schools need to be integrated. So then there are active efforts to integrate our public school system. And I think little Elizabeth Eckford has kind of gotten some attention recently with, it's just a lot of people put her in the shadow. There's a meme out there with Kamala Harris, and then, the shadow of Elizabeth Eckford. She was one of the Little Rock 9. They were 9 individuals, very bright, very intelligent, very brave, who were chosen to begin the desegregation of Little Rock's Central High School. So these 9 people are high schoolers, and they're tasked with going into Central High School and beginning the integration process. They are met with so much opposition. So these 9 high schoolers, and think about if you're in high school, or if parents, if you have high schoolers, and think about what you think they're capable of. These 9 individuals are going in, they're met with a mob of protesters, people yelling, screaming, spitting on them. They're not able to enter Central High School. They go back again, they try again. Local law enforcement is there, and you think, okay, local law enforcement is going to help them. No, in fact, the opposite. They prevent them from going in. The governor of Arkansas, Orville Faubus, deploys the state National Guard. It had not yet been federalized, and the National Guard is there and also prevents these Little Rock 9 from entering Central High School. And it's not until President Dwight Eisenhower deploys 1,000 federal troops that these 9 individuals are able to finally enter the high school. They entered the high school. I can't even imagine what kind of prejudice, discrimination, harassment they faced on a daily basis inside that high school. But they got in there, and I believe most, if not all of them, graduated from Central High School. So, the South in particular is a mess. They're really upset about this integration process. Some places are so upset, for example, Prince Edward County in Virginia, instead of integrating, decides to close all of their public schools. They didn't close for a few months like we're closed. We closed back in early 2020 for COVID. They closed for 5 years until they were ordered to open up integrated. In 1964, we have the Civil Rights Act of 1964. And it has different titles to it. Title IV addresses school desegregation specifically, and Title VI prohibits discrimination in federally funded programs. The Civil Rights Act of 1964 also bans discrimination in the private sector. If you remember back to the previous Civil Rights Act, that was the 1875, I believe it was, Civil Rights Act, that one was deemed unconstitutional. Congress finds their way around it. It's challenged again because how can Congress control the actions of private citizens and private businesses? And it is upheld this time, and it's upheld on the basis of the Commerce Clause. So Congress is charged with regulating interstate commerce, and the courts determined that private sector, so this is everything from hotels, restaurants, trains, transportation, bakeries, all of that is brought in under the Commerce Clause as things that impact interstate commerce. And so that now Congress can regulate that and prevent discrimination. So that's upheld. In 1968, this is under the Warren Court, and the Supreme Court is really upset about this. The desegregated schools, wants to integrate the schools. It's Green versus County School Board of New Kent County. The U.S. Supreme Court orders states to dismantle segregated school systems, root and branch. The court also dictates that there are 5 factors, which include facilities, staff, faculty, extracurricular activities, and transportation. Those are all to be measured in order to gauge compliance with the mandate of Brown, which is integration of the school system. And that was a unanimous decision. I do want to note that in a private note to Justice Brennan, Justice Warren, who was the Chief Justice at that time, he writes that when this opinion is handed down, the traffic light will have changed from brown to green. Amen. And in between all these cases that I'm highlighting, there are a series of other cases, but this is a general trend. Right now, the courts are on fire. They're mandating, they're going to make sure that this desegregation happens. So the traffic light changed from brown to green, but remember my title is brown, green, red. So let's find out what happens next. We get into the implementation error of the Brown case and the Green case. In 1969, we have a U.S. Supreme Court case, Alexander versus Holmes County Board of Education. And there the Supreme Court declares that the previous standard of all deliberate speed, which was, school systems need to work with all deliberate speed in order to integrate. Supreme Court said that's not good enough. You have to desegregate immediately. And that was a per curiam decision, which basically means they didn't have specific people, specific justices signing on. It was just kind of a blanket court order from the U.S. Supreme Court. In 1971, we have the Swan versus Charlotte-Mecklenburg Board of Education. And in that case, the U.S. Supreme Court approves active measures like busing, magnet schools, compensatory education, and other tools to remedy residential segregation, which was perpetuating segregated schools. So that's where you have kids getting bused from a lot of segregated, particularly inner city communities, going out to some of the suburban school districts. You have a lot. These are just active efforts in order to desegregate the school systems and make sure that more kids have an opportunity for a fair and equal education. So things are looking good. And then in 1973, we end up with this Keys versus Denver School District #1 case. And this is the beginning of the Supreme Court kind of pushing on the brakes a little bit. And in there, the US Supreme Court finds that this particular school board had intentionally segregated Mexican and Black students from white students. And the court begins this distinction. It distinguishes between state-mandated segregation, it calls that de jure segregation, and segregation that's a result of private choices, for example, like where you live, de facto segregation. And they rule that only de jure segregation is unconstitutional, de facto segregation is not unconstitutional. And that was a 7-1 decision. Later on, we have the San Antonio Independent School District versus Rodriguez case, where again, the US Supreme Court rules, and it rules that education is not a fundamental right. It also rules that the Constitution does not require equal expenditures on education within a state. So kids living in one district can have an expenditure that's much less or much more per pupil for their education than kids living in another district. So here's, kind of the protection that education gets is diminished, and then also that that right to an equal education is somewhat diminished as well. And that was a tighter decision. It was a 5-4 decision. In 1974, we have another very popular, well-known case, Milliken versus Bradley. This is actually a Michigan case that goes to the Supreme Court. And what happened in that case, background-wise, is that there were some students and parents who had sued the then governor of Michigan, Governor Milliken, alleging that there was discrimination and segregation in the school systems, that they weren't getting a fair education. And that went to the federal district courts here in Detroit. And the federal district court agreed with the students and their parents. And the federal district court took the active measures like they had authorized in Green in order to implement a desegregation plan. So the court, put certain standards in place, and there was active efforts to desegregate Metro Detroit's schools. By the time the case gets to the US Supreme Court, the US Supreme Court blocks that desegregation plan. And, it found that it basically said that, this is going too far. You don't need to, the district court shouldn't be dictating these desegregation plans. So then I just want to kind of step back and take a look at what schools are looking like. And, for all of these laws, you don't see the impact right away. It takes a good, 10 years or so to see the impact of those laws on the school system. So in 1988, we have school integration overall reaching an all-time high. And specifically, there were about 45% of all Black students who were attending majority white schools. And by 1990, we have the average Black and Latino student attending a school where only about a third of the children are from low-income families. So that's about, that right there is as good as we have had as far as integration goes with our schools. All right, so now we're getting into the red zone. Where in 1991, the Board of Education of Oklahoma versus Dowell, that's a US Supreme Court case where the Supreme Court ruled that desegregation orders are not intended to operate in perpetuity. Oklahoma is released from their obligation to desegregate. And like I said, there's so many of these cases going on all over the country. The federal district courts were very active in implementing these desegregation orders, and the US Supreme Court now is really putting on the brakes, and they're saying, hey, desegregation orders were not intended to go on forever. Once, they reach certain milestones, they can be released from their obligation. And so Oklahoma's released from their obligation in 1991, and note that they immediately return to their old neighborhood schools, which are segregated. And that was a 5-3 decision. In 1995, there's the Missouri versus Jenkins case. It's another U.S. Supreme Court case, which basically says that, we don't want to really be in the desegregation business anymore. The U.S. Supreme Court shouldn't be doing that. This really should be under local control. And judicial remedies, again, were not intended to be used in perpetuity. They should be limited in time and limited in extent. So, let localities do what they want to do. That was a 5-4 decision, another tight decision. In 2001, we have Congress enacting the No Child Left Behind Act, and there Congress required standardized testing to guarantee student proficiency, sorry for the typo, in math and reading from 3rd to 8th grade. I don't believe the intent of that was to further the inequality in education, but the result was that a lot of kids were not getting passed beyond the 3rd grade or the 8th grade. Note that in 2015, that was replaced with the Every Student Succeeds Act, which still has standards in place, but I think it was the intent was to provide more support and more remedial support for kids who are a little bit behind. In 2003, we have the affirmative action cases, Grutter versus Bollinger, Gratz versus Bollinger. These are University of Michigan cases. One was for the undergraduate program, the other was for the law school. And there, the U.S. Supreme Court rules that while race can be a factor in higher education admissions, race-based classifications must be directed towards a compelling government interest and must be narrowly tailored to that interest. They find that the University of Michigan undergrad point system is unconstitutional. However, they find that the law school's consideration of race didn't weigh as heavily on race, and that the law school system was okay. So they're really kind of nitpicking on what's okay and what's not okay, and that it's getting narrower and narrower what you can do. So the Grutter decision, which was the law school decision, was a 5-4 decision. The Gratz, which was the undergrad decision, which found the undergrad system unconstitutional, was a 6-3 decision. In 2003, there's the Harvard Civil Rights Project, and that project found that schools were more segregated in the year 2000 than they were in the 1970s. So we're really, there's evidence of our backtracking in regards to school integration. In 2007, there is another U.S. Supreme Court that stems out of Seattle, Washington, Parents Involved in Community Schools versus Seattle. And there the U.S. Supreme Court rules, and let me just give you a little bit of background on this case. The arrangement that they had in Seattle was that it was really like a school of choice system, and you can petition for admission in these different schools. The really good schools got a lot of people who wanted to enroll in those schools, and there were limited spots. So they had to come up with a system where they decided who got in and who didn't get in. And so with the best schools in Seattle, they had a system where they would assess certain factors and determine which kids should get in. I believe race was the second factor in their list of factors that they used. And the U.S. Supreme Court rules that where race is used as a tiebreaker in determining which students are admitted to popular schools, and Seattle at that time was trying to balance the school racial makeup proportionate to the community's racial makeup. And the Supreme Court says that racial balancing is not transformed from patently unconstitutional to a compelling state interest simply by relabeling it as racial diversity. So that's a big ding to essentially affirmative action and efforts towards a more diverse and integrated school system. And then let's just stop and take the pulse and see what's going on in, just a few years ago. And as of 2012, we have about 80% of Latino and 74% of Black students who now attend schools that are majority non-white, meaning the vast majority of Blacks and Latinos are in minority schools, and they're in schools where 2/3 of the children are from low-income families. Compare this to the 1970s, where they were in schools where 1/3 of the children were from low-income families. So they're in poorer schools, more minority schools. Also in 2012, we have minority high schoolers performing at academic levels that were equal to or below how they were performing 3 decades earlier. And in 2014, we have the average white student attending a school that is nearly 75% white. White schools are getting whiter. Black and brown schools are getting blacker, browner, and poorer. And so that's kind of the direction we have been headed. I did want to talk a little bit about some of the impact of segregation outside of the school system. This is more my expertise. I work in the child welfare and juvenile justice systems, and there's lots of evidence out there. Basically, there's a vast overrepresentation of Blacks, Latinos, and Native Americans in both the foster care system and the juvenile justice systems. The Native American issue is it's a whole nother presentation. Native Americans were shipped off to boarding schools some time ago, and there's a whole Indian Child Welfare Act in order to address a lot of the active discrimination against Native Americans. But for Blacks and Latinos, there are no special laws. As far as statistics go, about 33% of the kids who are in foster care are Black. However, often they only make up about 15% of the population. So the representation is double their population when it comes to being in foster care. Black youth are 5 times more likely to be arrested or incarcerated than white youth. And in some states, I think particularly on the East Coast, I saw a lot of states from the East Coast where that rate rises to 10 times more likely to be arrested than white youth. Studies have shown that the rates of abuse, neglect, and delinquency are not higher in minority families. So the next question is, why? How do we have all this racial disparity? And there's not a simple answer for that. There are so many stages, there are so many layers. And when you look at what's involved in a child protective case that results in a foster care placement, or in a juvenile delinquency case that results in a youth being incarcerated, there are, everything from neighborhoods and schools where a lot of those referrals begin. So, and there's racial disparity at each of these levels. So there's so many more calls to CPS regarding Black youth than there are calls regarding whites and others. The same with law enforcement. So there's so many more calls and requests for law enforcement involvement when youth are Black and brown as opposed to otherwise. We also need to look at intervention. So many of these problems are resolved and addressed at the community level. So for example, when a school has a concern about a child, be it that they come to school with dirty clothes, or they have a concern otherwise about the child, or say there's a school fight. law enforcement and CPS are more likely to be involved when that's a Black or a brown student as opposed to otherwise. I mean, there's, the teacher makes a certain decision, the principal makes a certain decision, the observers make certain decisions, and I have no doubt that there's bias at each and every one of those levels. There's disparate access to resources. So when it comes to therapeutic resources, food resources, housing resources, there's just so much history. And I know this is, Kara's done a series of classes on these issues. And it's just, we have this long history of discrimination and unequal and unfair treatment of minorities in our country, particularly Black and brown individuals, that you can't, with just a few years of trying to actively fix it, say you're done. Because we still have major problems regarding access to resources, desegregated communities, desegregated neighborhoods. And then there's the response by CPS, police, prosecutors in deciding, how to intervene in a particular situation. Do I remove these kids? Do I not? Do I arrest this child? Do I not? The prosecutors, they decide which kids get charged and which kids don't get charged. There are so many programs out there, diversion programs, which kind of tend to lessen the consequences for youth and provide more support for youth, deciding which kids get those and which kids don't. These are all decisions that are made by individuals. And so many of these individuals, knowingly or unknowingly, regardless of their background, have their own biases. And that has an impact. And then finally, the courts are kind of like the last, that's where, the worst cases end up, or the most severe cases are supposed to end up. And you have biases and prejudices even within the court system. And it's just this cycle, and it's all connected, and it just keeps going round and round. And I don't have all the answers about what needs to be done, but I did want to highlight lastly a couple of things. Some of you may be aware of, there was a recent Michigan case, Gary B. versus Snyder, where students in Detroit had sued, indicating that, they were going through the school system. This is a state-run school system, and they're coming out and they don't even know how to read. And so the case got up to the point of the Sixth Circuit, and the Sixth Circuit there had ruled that there is a basic right to a minimum education. And that case would have likely gone on to further and further litigation, but we did have a switch in governors, and we had Governor Whitmer come in, and she agreed that there is a basic right to a minimum education, that kids should be graduating from these schools, able to read, proficient in math, science, etc. And so there's currently a settlement agreement that's been reached in that case. As far as the whether or not affirmative action is going to stick around or not, I think there's a big question mark there. We talked about some of the recent cases, but there's been a lot of opposition to affirmative action efforts. I think there's also been a lot of attention recently to implicit bias, kind of recognizing that I think really each and every one of us does have some biases within ourselves, conscious or unconscious. And I know that there's been a lot of training efforts, and I think there probably needs to be more training on those issues. And then finally, no matter whether schools become more integrated or not, there has to be an investment in our schools and in our neighborhoods and in our community services for everyone. And this is, I know a lot of people are concerned about money and the cost of education, the cost of community centers, etc. But I see the other end. I see the kids who don't have an adequate school to go to. I see kids who don't have safe neighborhoods to play in, and we're paying for it either way. So if, those of you who are motivated by money know that it's going to cost you. I mean, right now, the amount that we spend on juvenile justice and adult jails and prisons, if we would just invest a portion of that into our schools and communities, we won't need to spend it on our prisons and jails. So really, we need to invest in all of our children and in our families. And with that, that concludes my presentation. And I'm going to try to get back to you. I don't know if there are questions or if there's anything else you'd like me to cover.
Thank you, Attorney Mona. That was an extremely informative presentation. I learned a lot. I did actually want to ask you if you could elaborate a little bit more on the issue of contemporary school segregation and the effects that it has on literacy rates. You did mention the case of Gary B. v. Snyder. What is a settlement agreement when it comes to what we're talking about, literacy rates and things of that? How do we move forward if we haven't really seen much progress within the past few decades? I was wondering if you could elaborate a little bit on that.
Sure. So, I mean, as far as my own personal knowledge goes, in my field, the work that I do, I work with kids who have delinquency cases and kids who are in foster care. And I work within Wayne County. The vast majority of our cases stem from Detroit. And I get these reports pretty regularly, and they'll assess a child's academic standards, where they are. And I can't tell you how many times my jaw drops. How many of these 16 and 17-year-olds are reading at the second grade level, or sometimes not even there? And it's almost, I don't want to call it the standard, but it happens so frequently. Like the vast majority of the kids that I work with, they're not up to, they're doing math and reading and basic things that they should know at a much lower level. As far as the settlement agreement goes, it is an agreement to put in more resources and provide active support educationally. So I don't know the details of the agreement, but I believe Governor Whitmer has agreed to provide funding and resources in order to improve the literacy rates of kids particularly in Detroit, because it's appalling.
It is, and I think you did a great job at really highlighting the injustices that we see within our school system and even within the justice system. I mean, you pointed out case after case on how the Supreme Court favored segregation or favored such immoral things. And if we think some Supreme Court being as supreme as they are, making these type of decisions where we send our children to school is a little scary. But I think you did an excellent job at highlighting how that's changed within the past few decades and the effects on that. And in some ways, things haven't changed. So thank you so much for your time and for your knowledge. We really appreciate it. And with that, I think we're going to wrap up. We have next week our final session, the last session of the history of resistance and racism in America. So inshallah, you all can join us for that. Thank you again, Attorney Mona, for joining us. And assalamu alaikum. Have a good evening.
It was my pleasure. Wa alaikum assalam wa rahmatullah.